All right, we are going to go ahead and get started with our second panel for this afternoon. Once again, I'm going to announce a change of personnel for this panel. Unfortunately, Erica Wilson. Melissa, corral your students.
Con law students, we're starting.
Unfortunately, Erica Wilson, who was going to be with us today, had an emergency and had to fly home. And so I have commandeered someone who I think you all are going to enjoy hearing from, this Melissa Murray person. So very, very happy that both Melissa and Peggy were so accommodating today when we lost folks. So the two other people on the panel this afternoon are frankly also people who really need no introduction, but I'm going to go ahead and introduce them. The first one is Professor Eric Foner. He is the DeWitt Clinton I was a little concerned that I would be the only one fangirling here, but I respect that. The DeWitt Clinton Professor Emeritus of History at Columbia University. He is, without question, one of this country's most prominent historians, and frankly, if you've ever taken American history class worth its salt, you have read work by Eric Foner. He's authored dozens of award-winning books, and of course, I can't name all of them, we just don't have the time for it. But some of them, Nothing But Freedom, Emancipation and Its Legacy, Reconstruction, America's Unfinished Revolution, 1863 to 1877, a book that I literally still have on my bookshelf from being a history major in college. Maybe I shouldn't say that, but that's okay. And that book won the Bancroft Prize, the Parkman Prize, and the Los Angeles Times Book Award. He's also written The Story of American Freedom, Who Owns History, Rethinking the Past in a Changing World, and The Fiery Trial, Abraham Lincoln and American Slavery, for which he was awarded the Pulitzer Prize for History, among a number of other awards. So we certainly could not ask for a better person to be here to talk to us about Reconstruction. Sitting next to him is Professor Dorothy Roberts, who is the George A. This is a good crowd, really good crowd. George A. Weiss University Professor of Law and Sociology and the inaugural Raymond Pace and Sadie Tanner Mosul Alexander Professor of Civil Rights at the University of Pennsylvania. She is also the founding director of the Penn Program on Race, Science, and Society in the Center for Africana Studies. She is one of the most preeminent reproductive justice scholars in the United States and frankly in the world. Her work focuses on family regulation, policing, science, medicine, and bioethics. She's written more than 100 scholarly articles and published numerous books, including Killing the Black Body, Race, Reproduction, and the Meaning of Liberty, which if you care about reproductive justice and you haven't read that book, you do not care about reproductive justice. Her other books include Fatal Invention, How Science, Politics, and Big Business Recreate Race in the 21st Century, and Shattered Bonds, The Color of Child Welfare, and the most recent one, Torn Apart, How the Child Welfare System Destroys Black Families and How Abolition Can Build a Safer World. So what a crew we've got going here. So I actually want to start with Professor Foner because I want to start with really, I think, sort of a basic discussion of the Reconstruction Amendments, in large part because, as we've already talked about today, in cases like Dobbs and SFFA, Shelby County, we could go on and on and on, there is a deep critique of how the court conducts its own historical analysis, especially given how crucial that analysis is to these decisions that they are making. So as someone who, as I said, is one of the foremost, if not the foremost historian of Reconstruction in this country, can you help us start to unpack the ways in which this court misunderstands Reconstruction and and again, we only have 75 minutes, but their deep misunderstanding of the Reconstruction Amendments.
Well, thank you. Before trying to tackle that, I want to just say it's an honor to be here and to help celebrate the work of Peggy Davis. On the screen up there, it talks about her scholarship, which is, of course, worth celebrating, but I am one of the few people here who has actually sat in on her classes here frequently. Each year she invites me to come to one of her classes, and we talk about Reconstruction and voting rights and other things, and I've seen her in action, as a teacher, and I've seen the enthusiasm that she generates among the students and the way their knowledge increases as the time goes on. So anyway, I'm happy to be here to celebrate her. You know, I think that as a historian, I don't think that the Supreme Court makes its decisions on the basis of a theory of history or a concept of historical evolution. But I think that there are at least a few of the current members who actually have a pretty strong interest in history. Not all of them get it right, in my opinion, and particularly the Reconstruction laws. The three persistent dissenters certainly understand the history of Reconstruction and the three amendments. Clarence Thomas is actually very interested in African American history. He cites it frequently. He reads books. He's even corresponded with me about some of the things that I have written. But I think his conception of it is all wrong, actually. So it's all based on an idea which is wrenched out of a speech by Frederick Douglass during the Reconstruction era about how now that the 4 million African-American slaves were free, they should be left alone. It's a sort of a pure libertarian or laissez-faire attitude about what comes after the end of slavery. And Thomas's view, which descends in African American life back to Booker T. Washington and others, is basically this idea that it's demeaning to receive assistance of any kind from the federal government. I could go on with that, but I would just say it does come from a speech of Frederick Douglass, but Douglass was also in favor of dividing land up among former slaves, establishing public school systems for both black and white people after the Civil War in the South, and many other forms of political intervention, so to speak, in the society. So but for many, many years, even though as I said, the history is not determining the outcome of many cases, I think it matters. Years ago, I wrote an article in the Columbia Law Review which tried to just figure out from footnotes and citations what the justices were thinking about Reconstruction. And one of the things I discovered, not really surprisingly, was they were locked into a vision of Reconstruction which had been really abandoned by historians. What we call the old Dunning School, which originated at my university, Columbia University, and in a way I'm the successor. When I was teaching there, I was the successor through a few generations of William Dunning, straight line down in teaching the Civil War era there, although our views differed considerably. But it took a long time for what I would call an up-to-date modern view of Reconstruction, which saw it not as a period of corruption, misgovernment, of Negro domination, as the Democrats of that period talked about, but as an important step forward for American society, and really a moment of opportunity that unfortunately was not grasped fully enough, although it certainly produced substantial change in American life. Today, the court is more aware of more recent works of history on Reconstruction. But I think the problem the problem we face on this is not that some of the justices are kind of wrong about this point or that point, but the very concept of how history is used in decision making on the court. The principles, now let me just say to begin with, I am not a lawyer, I am not a law professor. Some of my friends are lawyers, they're okay. But I can't sit here and exchange case law with people, and I don't even think I want to do that, actually. But whether it is the notion of original intent or original meaning, I don't think there's a serious historian in the country who doesn't understand that those ideas are intellectually incoherent. There is no important document in our history that has one single meaning or original intent. As a historian, it is certainly worthwhile for me and others to study what the people who drafted and ratified the 13th, 14th, and 15th Amendments had in mind, what they were trying to accomplish. That's a legitimate historical question. As soon as you move to this thing of, well, what was their intent, and assume that that intent is frozen throughout all of Reconstruction. History is the study of change. That's History 101 in high school. History it's the study of context. It's the study of evolution, of change. Now, Reconstruction was a period of radical change, and there was no intent or meaning that just stayed static through that period. So the quest for these things is actually misguided to begin with, and therefore is not going to yield you very useful answers, I don't think. Then there's this question, people here, of course, know this phrase now, history and tradition. You can't have laws, they are not constitutional if you can't find antecedents to them 200 years ago or something like that. It sort of reminds me of a well-known, at least among historians, document from a letter by a African-American woman who was the mother of a black soldier in the Civil War in 1864 to President Lincoln about the Confederate pronouncement that black Union soldiers would be considered slave rebels. They would not be treated as prisoners of war, but they would be executed as slaves trying to create a slave insurrection. And the mother of one of these soldiers wrote to Lincoln saying, "You're going to have to retaliate. It's a terrible thing. We don't want to just start killing people back and forth, but you have to retaliate and not let them do this." And then she says, it may violate the law, what you're doing, but who made the law? That's my answer to this whole notion of tradition and who made the law. Why are we stuck, frozen in a history created only by white men, basically, when women had no political rights, when in most states African Americans had no political rights, and yet this is supposed to determine what laws can be approved and what cannot be. So the very effort that they make on the court, at least the majority, the supermajority, to define the constitutional meaning of the three amendments is pretty much misguided from the beginning, in my opinion. I don't claim I can convince every law professor of that or not, but as a historian, it's misguided. It's not the way you should study that period. As I said, we can't be frozen in a interpretation of the three constitutional amendments, because where was I going with this? Wait. The point is that people were changing radically. Wendell Phillips, the great abolitionist, said, "We're living at a moment when 1 year counts for 100. People who started out Reconstruction saying, I will never support African-American suffrage. Yes, of course, they're free, and they should be free, and that's a great accomplishment, but that's why the 14th Amendment does not provide for African-American suffrage. And the 15th does, of course. But then people changed their mind. The same people who said, I'll never vote for that, voted for it. The same people who said that we must not pass laws that only apply to one race or other, but then they passed the Freedmen's Bureau Act, which did apply almost entirely to former slaves. It's this radical change in ideas that is the creative element in the Reconstruction era. And, you know, we've heard a lot this week about Section 3 of the 14th Amendment. What about that quiet little Section 5? 5, I'm not talking about number 1, Section 1. Section 5, very simple, right? Congress shall have the authority to enforce this amendment with appropriate legislation. This was a warning and a statement and a prediction that there was going to be more Reconstruction. They envisioned it. They put it into all of them, 13th, 14th, and 15th Amendments, that Congress can take out, whenever Congress determines that the purposes of these amendments are being violated, it can step in and act. The majority on the Supreme Court today acts as if the federal system itself remained unchanged. This is during Reconstruction. This is completely wrong. They were now taking steps to revamp the whole political system of the country, and particularly in the South, to make sure that what Republicans in the North call the slave power, that is to say the pro-slavery elites in the South, did not come back into power in the South. And by the way, despite Section 3 and President Trump and all that, that's not what they were trying to do in Section 3. That was about the southern states, not about the president. They could get rid of Andrew Johnson, at least they thought, by impeachment if they felt like it, which later they tried, of course. But it was part of this effort to make sure that the consequences of the Civil War were written into the Constitution. If you want to know what they're trying to do, that's what it is. Put into the Constitution the Republican vision of what the Civil War had accomplished. They first do that with the 13th Amendment, obviously. Mm-hmm. The 14th Amendment touches all sorts of bases, as you know, Section 4 with all the different things. That's because they're trying to hit every important thing that needs to be preserved, whether it's paying the national debt or making sure that slave owners don't compensate themselves for the loss of their slave property. I'm not even talking about Section 1, which has most of the jurisprudence. My long-winded answer to your question is that the problem with the Supreme Court nowadays, at least the majority, is not that they get some facts wrong, that they didn't read my books, although Clarence Thomas did, and I commend him for that. And, but that the whole intellectual structure of how they look at the meaning of Reconstruction is itself fatally flawed. How to get around that, I have no idea, and I can't predict who's going to be the next people on the Supreme Court, et cetera, et cetera. All right, I'm going to stop there. I could ramble on about this, obviously, but it's, their way, the 6 members' way of looking at Reconstruction, as I say, is not very valuable from a historian's point of view.
So we're gonna send them this recording when we're done, and hopefully that'll do the trick, or at least start them down the right path. So Melissa and Dorothy, I'm gonna ask you a bit of an unfair question, because it's sort of like saying, which is your favorite kid. What's one of, I think I often say to myself, is what we are seeing here just cherry picking pieces of the history, or is it sort of actively distorting pieces of the history? And I'm curious from both of you, if you could just pick out your favorite, right? Your favorite way in which this court has either cherry picked or distorted in order to get itself to a particular outcome.
Favorite meaning least.
Yes, exactly.
Hated.
Most horrifying.
Hated.
Yes. Or most dangerous.
Well, it's hard to, first of all, yes, all praises due to Peggy Cooper Davis, who not only wrote Neglected Stories and other absolutely essential works, but was my own personal mentor when I started teaching in 1988. So I want to just thank you so much for that guidance personally, as well as your terrific work, which has inspired this fantastic symposium today. So there's so many. I think Dobbs is clearly at the forefront. Professor Foner said that the Supreme Court doesn't really have a theory of history, but in a way it does have a theory of history, as you pointed out. The court does look to history to try to justify its decision, and its theory about the Reconstruction Amendments is also tied to its theory about the Civil Rights era, and the idea that the Civil Rights era completely ended the post-Reconstruction era of segregation and the Jim Crow regime. And so now we don't have to worry about racism anymore because of that civil rights victory. And the idea that the Reconstruction Amendments had nothing to do with reproductive justice is one of the great distortions of recent Supreme Court decision-making. Not only that there are rights of the fetus or state's interest in potential life that override decisions to terminate a pregnancy, but it's complete dismissal of the value of pregnant people's lives, not just their autonomy, but their very lives. And to root that in an understanding of the Reconstruction Amendments is just atrocious, because the Reconstruction Amendments, and this is one of the reasons why Neglected Stories is so important, it's not just what they say, it's why they came about. They came about as a result of an abolitionist movement. So when you interpret them, you have to interpret them as the outcome of abolitionist organizing, abolitionist principles, abolitionist protests, hundreds of years of enslaved people rebelling and resisting. All of that is what the Reconstruction Amendments mean. And as Neglected Stories show so vividly, it was a result of the stories of enslaved people saying what were the horrors of slavery. And among those horrors were compelled births, were destruction of families, were the deprivation of family autonomy, the deprivation of autonomy over your body. And so all of that has to be taken into account in understanding the Reconstruction Amendments. And so to say that there's nothing in them that would support the right against compelled birth, the right to abortion, is completely, it's worse than ahistorical. It's a complete distortion of history. I know Melissa may want to talk about this because you've written a law review article about Justice Thomas's. Okay, so Justice, she has her own, there's so much to hate that, Justice Thomas in his concurrence then going even further to say that abortion care is a form of eugenics, and reaching into the eugenic era to claim that that is a historical basis for denying the right to abortion, then again completely flips. This is what's so annoying about Clarence Thomas, is the way he completely turns around the meaning of freedom. To be able to say that that current affirmative action programs that take race into account are equivalent to Jim Crow, white supremacist measures to deny black people's rights. They're the same, he says. That completely flips what white supremacy means. And so that's especially annoying. So equally annoying is the way in which, annoying, infuriating, is the way in which Thomas says that abortion care is a form of eugenics and refers to the eugenicist era as support for that, when in fact, eugenicists relied on sterilization. They didn't rely on abortion. Margaret Sanger, who he points to as a eugenicist, and we won't go into, she did spout eugenicist ideas and rhetoric, but she never relied on abortion. She advocated for birth control, mostly in the form of diaphragms. Mm-hmm. And black people wanted the expansion of birth control, which they were not, didn't have full access to. They don't understand, Thomas apparently doesn't understand the difference between being forced to use birth control, family planning, forced sterilization, and having the freedom to access abortion and other forms of reproductive health care. Those are completely consistent ideas that you would oppose forced reproduction and you would support reproductive freedom. So in the end, we end up with a decision that compels people to give birth on grounds that somehow we could support it in the history of eugenics. Mm-hmm. It's the opposite. It's the opposite. The freedom to terminate a pregnancy is liberating. Being forced to use any form of birth control, but forced sterilization, is obviously oppressive. And so that's part of the reason why Dobbs is just so infuriating, so horrific. And we started to talk this morning about some of the consequences. I won't go into all of them, but they're vast. They're vast. The division of our nation into free birth states and compelled birth states, and what that means for the ability to travel, what the way in which it's putting impossible pressures on states that have liberal abortion laws, because so many people are coming into the state, like this state, New York State, mm-hmm. to get abortion. Well, there's not enough clinics to handle it. The police state that's being developed, because you're supposed to rat on your neighbor, and nurses are doing this, and doctors are doing this, and the criminalization of pregnancy, which we touched on a little bit this morning. The punishment of people for not having a healthy birth, punishing women for stillbirths and miscarriages. The reverberations are enormous, all coming out of this complete distortion of the abolitionist animation of all the Reconstruction Amendments, and the way in which the court, as Professor Foner said, looks at this static view of history, when in fact what the Reconstruction Amendments represent, as I've called it before, the abolition constitutionalism, a transformative view of thinking about the Constitution, an imaginative view that continues to move forward as we recognize that we haven't fulfilled the dreams of either the abolitionists who overthrew the slavery regime, or the civil rights abolitionists who overthrew the Jim Crow regime. We have to continue in new ways, and this court has developed multiple ways of stymieing and even reversing those kinds of progressions. And I'll just name 3 of them, and then we can talk about them later if we have time. But colorblind ideology is one, that any attention to race after the civil rights movement is racism, reverse racism. The intent to having to prove intent to discriminate, looking for these kinds of pre-civil rights blatant acts of discrimination and racism, and then the fear of too much justice, that are basically the admission that structural racism is so deep that if we actually apply the Reconstruction Amendments, it's going to cost too much justice in America, and so we can't even make little steps toward it. But
Have to give all of us
I'll
40
end
acres
there.
and a mule.
it
All fall apart.
Exactly.
Melissa?
Well, I'll just say I'm obviously an understudy here, and I was worried that I wouldn't have anything to say because I joined this panel late. But then you said we're going to talk about everything we hate about the Roberts Court, and I was like, I have so much to draw on. This is great, and I also didn't realize people like Justice Thomas could be your pen pal. So like I'm actually aspiring to that now.
I was thinking we shouldn't blame Eric for.
No, I want a letter. I do want. I would like some correspondence. Okay. So I think one thing that's really important to recognize is the use of history. I mean, that's what I take the question to be. Like, what do you make of this new fascination, interest in using history? What is it for? And as Dorothy said, it is justificatory to justify the major rollback of rights that this court is doing, the withdrawal of rights under the guise of a history that purports to be objective and neutral. Right? And it's not. And the withdrawal of rights also isn't neutral. In terms of my most hated use of history by the Roberts, I mean, like, there's just so much to draw on. And, Dorothy's told one of them, the association of abortion with eugenics, which I think is absolutely abhorrent for all of the reasons Dorothy suggests. But I want to talk about a different one that is actually probably more under the radar and maybe even more anodyne and not as obviously malignant as I think it is. And this is the Chief Justice's invocation of Brown versus Board of Education and relatedly Cooper versus Aaron, the post-Brown case in which the court rebuked the South for massive resistance to Brown. And this emerged not in an opinion, but rather in the Chief Justice's 2022 year-end report on the federal judiciary. And this is something the Chief Justice puts out every year as part of his role as the Chief Administrator of the federal courts. And in 2022, there was a lot that the Chief Administrator of the federal courts probably had to say about a court that had radically expanded the scope of the Second Amendment and completely contracted the nature of fundamental rights in Dobbs. But the Chief Justice didn't talk about any of that, at least not explicitly. Instead, he began the 2022 report with an invocation of a man named Judge John Davies. So who is Judge John Davies, you might ask? Well, Judge John Davies was a district court judge from Minnesota who sat by designation in Arkansas in the wake of Brown when the Little Rock Nine were attempting to integrate Central High School in Little Rock. And it was unusual that the Chief Justice sort of focused on Judge Davies because there were lots of other players in this political milieu in Arkansas at the time. Thurgood Marshall was representing the Little Rock Nine. He would, of course, go on to be the first African American to serve on the court. Also representing the litigants was Wiley Branton, who was an Arkansas lawyer who would later go on to be the dean of Howard Law School. The Chief Justice mentions both Justice Marshall and later Dean Branton briefly, but his focus is on Judge John Davies. And he talks about Judge John Davies as the stalwart defender of the rule of law. He knew what the South was doing. He saw what Little Rock was doing. He saw Elizabeth Eckford walking through that gauntlet to integrate Little Rock, and he stood firm. Even though so many would have liked to see him stand down, he stood firm and he enforced what the court said in Brown, and he demanded the integration of Little Rock. And it was telling that he chose to focus on Judge Davies because it was clear he was associating himself and his court with Judge Davies. That in the face of protests about Dobbs, lawless rabble who would take to the streets in defiance of this court opinion, who would go to Justice Kavanaugh's house, possibly with the intent to do harm to him, he was associating his court and that majority with Judge Davies, who wrote an opinion enforcing the rule of law, even in the face of public pressure to do otherwise. Now, it is interesting that he invoked Judge Davies because there were other judges he could have invoked, including Judge Lemley, who was the district court judge who, a year after Judge Davies allowed for the integration of Central High School, heard another case, this time brought by, again, the same litigants, but against the school board, because the school board, in the wake of that first effort to integrate Little Rock High School, Central High School in Little Rock, decided that things had become too tense. Like the effort at integration was actually too disruptive. And there was an actual trial in which Judge Lemley heard evidence from the Central High School math teacher who talked about how hard it was to teach this integrated mass of students when there was so much going on, the presence of federal troops, bomb threats against the school every day, and of course these black students who by their very presence were somewhat disruptive. And Judge Lemley heard all of that evidence, like many teachers gave evidence, many community members gave evidence, and he writes in this opinion, it is very clear that what is making the situation so volatile, so disruptive, it's not the students, but the fact that no one in this community, no white person, wants integration. And even recognizing that it was popular antipathy for integration that was guiding this, Judge Lemley notes that the Brown decision and Brown 2 didn't say you had to integrate right away, but you had to do so with all deliberate speed and with attention to the pedagogical mission of the public schools. And he says, well, the pedagogical mission is being completely subverted here. And so I'm going to pull back and I'm going to allow the Little Rock School Board to defer their integration until things settle down. Right? 2 judges, 2 histories, both available, but the Chief Justice chose to focus on the judge who stood firm against the rabble. And he chose to align his court and to recast the Dobbs opinion as an effort to enforce and recuperate the rule of law, as opposed to what it actually was, a withdrawal of constitutional rights, an FU to stare decisis, and a decision to completely disregard the equality dimensions of what that fundamental right would mean for millions of people around the country. And so we can't think about how this court uses history, and certainly the originalism it seems to subscribe to in this history and tradition method, without understanding that it is entirely outcome-driven. And it is selective and itinerant because it is outcome-driven. It is a methodology that was forged in the crucible of the Reagan administration's Justice Department under the auspices of Ed Meese. Like, that is where originalism comes from. That is the hothouse that bred this. And it was bred for a purpose, to roll back the supposed excesses of the Warren Court, the one time in history when the Supreme Court has actually not functioned as a regressive force.
Thank you. Understudy, right? She calls herself an understudy. So I want to actually drill down on one of the things that you said, Melissa, which was this idea of sort of what the people want versus what the court does. And so I think sometimes we hear these stories, right? So around sort of marriage equality, people said, oh, the court was sort of moving towards where people were moving. And then Dobbs, of course, is completely out of line with what we know the majority of Americans want. I'm curious whether you think there is any role for public opinion, public expectation, majoritarian ideals about what this country stands for, in how the court should be thinking about its jurisprudence. Anybody? But you can start. Yeah.
Well, so one thing I didn't say is that the invocation of Judge Davies is also an effort to, it's not just an effort to recast the court, it's an effort to recast the public. Like, we who are protesting Dobbs are now the same as those segregationists who opposed Brown. I mean, so it's like to cast us as lawless rabble railing against the court. And I think that's also purposeful because we are in a moment where public opinion of the court has never been lower. The court has never had more eyes on it. And I'm happy to be a part of that. Strict Scrutiny, the podcast about the Supreme Court and the legal culture that surrounds it. We should be focused on the court. And so they know that we're watching. This is why, Justice Alito is giving interviews to David Rifkin, who is not just a sometime journalist with the Wall Street Journal, but also happens to be an advocate who appears before the Supreme Court, including in this term in a major tax case, Moore versus United States. He gave an interview where he talked about how the public wasn't supporting the court, and it was so bad that the public was beating up on the court. So he clearly cares about what the public thinks about the court. I think that's hugely important because if they know we're watching, if they know we're responding, that is probably as palpable a check on them as we are going to get at a time when Congress is too polarized and the executive too fragmented to actually serve as an actual check on the judiciary.
But it is said in the press, it is said in the press that Chief Justice Roberts, anyway, is very concerned about the disrepute to which the court has fallen, and tries to. I don't know if this is true or not, of course, but I'm just saying that this is floating around Washington. This idea that Roberts is trying to find ways of accomplishing a conservative agenda, but somehow not letting people realize that that's what happened. Or even in Dobbs, was trying to get a ruling that didn't explicitly overturn Roe v. Wade, but had the same basic effect as what came out, but that at least 2 and maybe more of the 6 people majority brushed him off and said, no, forget it. We're here. We have the power. We're going to push ahead with the total agenda. So do you anticipate, I'm jumping into the role of moderator here, but I'm just wondering, do you think this is true, that there is actually, that Roberts feels some kind of pressures on him from public opinion, and that therefore subsequent decisions are going to be not quite as outrageous as recent ones have been?
So I agree that Chief Justice Roberts, because he is the Chief Justice, is probably the most stalwart institutionalist on the court. He cares about the court's institutional legitimacy. I think that's why the 2022 year-end report was written with this paean to Judge Davies, again, to make the court look better, to rehabilitate what the court had done because the public opinion had been so outraged. Again, the Chief Justice wants to get to a conservative outcome. He was one of the lawyers, the baby lawyers, working in the Meese Department of Justice, so he's not outside of this conservative project. He's just driving a Dodge Dart to get there. But he has 3 movement conservatives who are in a Tesla and know that they can get there faster. And why would you let this conservative supermajority go to waste by going slow? And this also, I think, feeds into all of the ethics scandals, the whole question of whether you can have a GoFundMe campaign for a justice. All of this is about doing the most while you can with the majority that you have.
Yeah, and it does seem impossible to undo that at this point, that they're going to go ahead in the Tesla and they're going to keep making these right-wing decisions. But we also know from history that mass movements can make a difference to court decisions. That's why we got the Warren Court decisions, because of a long-standing, decades-long, organized civil rights movement that involved brilliant leaders in multiple organizations, as well as thousands upon thousands of everyday people boycotting, striking, protesting, it made a difference. Those decisions, they're not enough, but they made a difference. They did end de jure racial segregation in the South and other parts of the country as well. So we know that can make a difference. We also know that now it's making a difference in local, state referenda, in decisions that Pennsylvania Supreme Court, I'm at Penn, and that's my state Supreme Court, just issued a decision last week finding a right to abortion in the state's equal rights amendment to its constitution. So, and of course we see this, in Ohio and Kansas, where the protest against the Dobbs decision can be successful at a different level, not before the U.S. Supreme Court. And then, these dissents, I think was it you this morning, Melissa, praising some of the dissenting decisions? I know Maya did as well.
I think Serena.
Serena, yes, Serena. Yes, of course. Thank you, Serena. Justice Jackson, Sotomayor's, just really amazing dissents that they don't make an immediate, direct difference, but they make a difference to how we think about these legal issues, and they can be inspiring to movements, and they can lay the precedent for the future. We have to have a long-sighted view of the movement that we're building to have a free society. It's not going to happen right now with this Supreme Court, but just like the right wing has had a long-standing strategy that is now coming to fruition big time, we have to do that too. And so,
Patience and money.
Exactly, and people power, collective people power. Yeah,
absolutely. So I want to talk, because you said exactly what I've been feeling, what I think a lot of people are feeling, which is the Supreme Court is not going to be helpful, and it's not going to be helpful for quite some time, right? Some of those people are just too young. And so what that leaves us with is, if we want to be moving forward, we have to do it on a state level. We have to do it on a local level. And so can we talk through that a little bit, what that sort of looks like, particularly at a time where we're actually seeing some of these states where you get these ballot initiatives, the legislature is like, oh no, we can't do that, right? So now we want to change the process of how you get an initiative. We want to change what percentage of the vote you have to get in order for that initiative to pass. We want to change who gets to enforce these ballot initiatives. So in the face of that, where are we supposed to be going right now? What are we supposed to be doing? I know we're not going to the Supreme Court, right? So where are we going?
Well, oh, sorry. I'm sort of a congenital optimist, although it's hard right now. But there are. You're absolutely right. We can't expect anything from this particular court, but there is another jurisprudence out there, a kind of shadow jurisprudence, which developed. First of all, I'm very glad you pointed to the abolitionist movement, because before the Civil War, there was a big debate about the Constitution and its relationship to slavery, obviously, and an anti-slavery constitutionalism developed in the abolitionist movement. And the people, when you talk about, well, what were they intending to accomplish, they had already mapped out the idea of equal citizenship regardless of race, and universal suffrage, or at least for men at that point, and what the Supreme Court would knock off in the civil rights cases in 1883, the right of anybody to get on a bus or public accommodations and to win damages if they were not allowed to do that. In other words, much of what was in these, what I call the second founding, was already out there as an alternative possibility if times changed. And the same thing happened during Reconstruction. It was right at that moment that the Howard University Law School was created. And this began training a cadre of African-American lawyers for the first time. And they they began developing a different interpretation of the 13th, 14th, and 15th Amendments. They were very disappointed in the initial Supreme Court decisions, whether it was Slaughterhouse or Cruikshank or civil rights cases or others. But they didn't just sit there. They said, no, here's what these amendments really mean. And now the Supreme Court never adopted their view, but it was out there as a possibility. And when times changed, when the makeup of the court changed, some of those things were picked up then and implemented. So, to my mind, one of the things we have to do is to figure out ways of putting a different jurisprudence out there for people to see. We remember John Marshall Harlan today. I don't think we remember most of the people who were on the Supreme Court in the 1880s and the 1890s. But Harlan's views, kind of triumphed in the end. Not every single one of them, but mostly. And that's one thing that I think that people should do. And you said the social movements are essential to this. It means that when some kinds of vacancies appear, we don't know when, we don't know who, there's the opportunity for shifting the decisions that are out there right now, challenging them.
So I'm going to open it up for questions, so people should start formulating their questions, and whoever has the microphone. Thank you, Megan. But I want to ask one more question, which is, we talk about the Reconstruction Amendments, and we spend sort of all of our time on 14 and 15, right? And very, very little
All of our time with...
on the 14th and 15th Amendments.
Oh, all right.
Yes.
You want to hear about them too?
Yeah.
The
So
13th.
with the 13th Amendment, right? I mean, that's one where we don't hear as much discussion. We have some people writing about abortion in the 13th Amendment now, which I think is super interesting. People raise it obviously in the context of criminal justice reform and our prison system. But why don't we do more, right? It's there, it's useful, it has things to say, and particularly to the extent, as we said before, if we're supposed to be reading these amendments together, right, then why are we leaving that on the table?
It gets awfully complicated, as history does.
Put your microphone closer.
Oh, sorry, yeah. It gets awfully complicated, as history usually does. All three of those amendments were compromises in a way, or at least were imperfect, certainly. The 13th had this criminal exemption, which has been a terrible, now, I'm not a conspiracy theorist about that. They didn't put that in order to anticipate mass incarceration 80 years later, But they did open the door to convict leasing and all that kind of stuff. The 14th Amendment was, the Section 2 was a totally convoluted compromise about some Republicans were willing to go with African-American suffrage, some of them weren't. They split the difference in Section 2. By the way, another movement we ought to have is a movement to enforce Section 2 of the 14th Amendment. States that have now deprived enough people in their state, enough citizens of the right to vote, should lose one or more members of the House of Representatives. And my calculation suggests that certainly Texas would, because it has so many, has so many congressmen. They have disenfranchised a good number of people. So, but even others, but they couldn't, and then here's a little-known fact, a story in Peggy's tradition, of the 14th Amendment, when it was not ratified until Congress passed the Reconstruction Act of 1867 and gave the right to vote to African-American men in the South, and new governments were created in the South. And then those governments were required by Congress to ratify the 14th Amendment, which they did. But without black suffrage, without black men in the legislatures then, no 14th Amendment. And yet, when people, talk about the purposes or the intent or whatever of the 14th Amendment, they never quote black people. There is no black voice because the concept...
Peggy Cooper Davis. Peggy's book, Neglected Stories. Yes, but go on.
The concept the concept of how you study this original ideas is you go to legislatures. There were no blacks in legislatures the first time it went through. You go to Congress. There were no black people in Congress in 1866 when they were debating. Later on, of course, there were. And yet there's no black voice. The methodology itself determines that they're going to misunderstand the 14th Amendment because of the way they only go with people who were holding office. You know, okay, what did John Bingham say? Or what did Senator Howard say? Fine. But, you know, in the state legislatures, there were perfectly good African-American people who also had ideas about what the 14th Amendment was all about, and yet they don't get into that, that discussion at all, which leads to, as I say, considerable confusion, to say the least, about what was really the purpose of in 1867, 1868.
Thank you, and thank you so much to the panelists. Jean-Pierre Brutus, New Jersey Institute for Social Justice. So my question is related to the previous question that was the last question next to Maya Wiley, which I think is an incredibly important question, which is about racial capitalism. But the question I have for you is more specific, is within the context of Reconstruction, the Freedmen's Bureau, could you talk a little bit about the attempts to sort of reclaim property from Southern slaveholders, particularly to give to formerly enslaved? The reason why I bring this up is, you know, South Africa was brought up as an example constitution, but South Africa is a deeply unequal society, partly because so much land is owned by former white colonial authorities. Secondly, Zadia Hartman was brought up, but Zadia Hartman has pointed out in Scenes of Subjection that for the formerly enslaved, freedom was a burden of individuality. It was the sort of freedom to starve, right? There was no accompanied economic capacity or power, right? And so the question I have for you is, do you think there is a role for the Reconstruction Amendments, or how would you conceive of the role of these amendments or the law to intervene in the political economy, particularly given the kind of underlying sort of liberal ethos of liberalism shaping, you know, this kind of framing of individual rights as opposed to collective rights? And then the idea that if these Reconstruction Amendments are the sort of enshrining of radical Republicans' views, and also a kind of, on the other side, the views of abolitionists, there would have to be some acknowledgement that the slave power also was diffused through northern banks, insurance companies, factories, right, and so forth. And so part of, you know, we talked about the second Reconstruction, as you point out in your review of Jonathan Ick's book about King of Life, right? King was well aware of economic justice and the need for that, right? Mm-hmm. And Du Bois in Black Reconstruction talks about abolition of democracy, talks about this kind of renarration of, you know, Reconstruction to essentially take down the Dunning School. But it is a narration that takes into account racial capitalism, right? And so the question I have for you is there a role for Reconstruction Amendments? If there is, what should that be in addressing sort of the role of capital? Because questions about autonomy are economic questions, right? Questions around race are economic questions as well, right? To use Professor Murray's point, they're imbricated, right, in a sense. So I just wanted to ask you that question.
Well, that's a long question, let's put it that way. And that it would require a long answer to completely answer it. But obviously, the question of land for the former slaves was on the agenda at the end of the Civil War. General Sherman had issued Field Order 15, which is the 40 acres and a mule document, which sets aside 40 acres of land and a mule if they felt like having one, in the coastal areas of South Carolina and Georgia. Thaddeus Stevens in Congress was pushing for the confiscation of the land of planters and redistribution to former slave families. In other words, this idea was in the air. That never got enacted, obviously, but in a sense, more relevant to the question is the notion of free labor and what that involved, where you get back to the 13th Amendment. What did it mean to be a free person in the United States at the end of the Civil War? What did it mean to compete in a free labor market? what kind of assistance would the federal government give? They set up the Freedmen's Bureau. Remember, the title of the Freedmen's Bureau, the name of the bureau was the Bureau of Freedmen, Refugees, and Abandoned Land. The promise of land was right there in the title of the Freedmen's Bureau. President Andrew Johnson dismantled this policy. He gave back the land from General Sherman to the owners. Big conflict over that, of course. But I think to go back to the people I mentioned from the Howard University Law School and the first generation of large numbers of black lawyers, by the 1880s, again, they were there was a group I wrote about, the Brotherhood of Liberty, black lawyers in Maryland, who put forward an economic analysis of what citizenship ought to entail. And, it's in my book, the Second Founding, but they said, they talked about things like access to a job. Lincoln had talked about going to work for reasonable wages in the Emancipation Proclamation. He urged the emancipated slaves, go to work for reasonable wages. Reasonable wages was now part of the sort of Republican concept of what free labor was to entail. So I think there is ground for an economic analysis of the implications of the 14th Amendment, but on the other hand, see, this is the difference between law schools and history departments. In history departments, it's always, but on the other hand, you never get a straight answer about anything. You put out a thing and say, oh, but yes, but the other side is, here's what's happening. But on the other hand, the Republican Party was itself a kind of strange coalition between the poorest people in the country, the African American slaves in the South, all voting Republican when they got the right to vote, and the richest people in the country, the industrialists in the North, who were Republican also. There was no coherence in the economic outlook of the Republican Party, and that was a big problem for the success or failure of Reconstruction. Du Bois talked about abolition democracy. He also talked in that great book about the inability to combat, in the North, to combat the sort of what he calls the plutocracy, the well-to-do industrialists and merchants and others. So it made it very difficult to come forward with a coherent economic policy under the 14th Amendment or any other legislation.
Can I just add, Eric's colleague at Columbia, Catherine Franke, has written a tremendous book, I think it's from 2020, called Repair, about the effort to return or recuperate some of that land in the South and give it to newly freed African Americans. And she talks about the Sea Islands as well as Jefferson Davis's former plantation. So I recommend the book. I would also say that it's not entirely clear to me that we haven't had a political economy analysis of the Reconstruction Amendments emanating from the Supreme Court. I think it's Lochner versus New York, right? So, in Lochner, the court talks about this idea of progressive labor legislation enslaving laborers who ought to be free to negotiate the terms of their labor with their employers for themselves. And it's not surprising that this rhetoric would be repurposed to thwart labor organizing in the progressive age, because there's a court determined to limit these gains. So I would just say that and relate it back to the earlier question, should we be focused on courts? Where should we be playing? Obviously, I'm very much in favor of a jurisprudence of dissent, but that is tilling fields that will not bear fruit for some time. We also have to play in fruitful fields that are blooming right now, which means we have to be focused not only on state courts, but state legislatures, state executive officers like prosecutors, district attorneys, local school boards. It's not a coincidence that you are getting bans on books that would talk about this history, that you are getting curricular reform that won't teach Reconstruction at a time when this court is trying to enshrine a stilted vision of that history for the public. They don't want people to be able to refute it. Right? So to be able to do this work, we have to think about the court all the time, but we also have to play in other fields. You have to do everything all at once. And it seems exhausting, it seems unmanageable, but it can't be, because that's the only way to move forward. They have the luxury of playing on one field at a time. We do not.
Just to add a little bit to that, I think it's very clear that the institution of slavery was a racial capitalist system. The entire notion of dividing our society into races with an enslaver race and an enslaved race was in order to build up the economy of the nation on the backs of forced labor. So there's no way to think about slavery and its abolition apart from thinking of it as in the service of racial capitalism, and therefore its abolition should be abolishing that racial capitalism in its forms today, as well as in the pre-civil rights slavery era. And how do we interpret then the Reconstruction Amendments? Again, is it that we just look at how it's been interpreted in the past and hold on to that? Or do we think about the abolitionist purposes and aims and imaginations and visions that brought about the Reconstruction Amendments? And if we think about it that way, that latter way, then we need to think about how do we undo a racial capitalist system. And as Melissa was just saying, we have to look at every possible way we could do it, including not even beyond going to the courts and going to legislatures, but building our own ways of addressing human needs without relying on these racist capitalist systems, and promoting, I think we need broad government policies, but as well as community-based networks that provide for people's needs. So we need to do all of that, but I like to look more at the abolitionists, including Du Bois, who, as Eric Foner said, as you said, called for an abolition democracy. In other words, you have a victory, but when you see that it hasn't achieved the abolitionist vision that the pre-Civil War abolitionists had, you have to move on and do more than that. You pointed out Dr. King. Dr. King said, what's the point of having an integrated lunch counter if you don't have a job that can afford a hamburger and a cup of coffee? And he then advocated for a poor people's campaign and a new economic deal. He went beyond the civil rights victories because he saw that they had failed, just like the Reconstruction Amendments had failed, but we build movements that use whatever tools we have to imagine a truly free and democratic society and move toward that. And I agree with you, that includes a radical economic redistribution of wealth, along with ending white supremacy and racism.
Hi, my name is Kendall Long. I'm a 3L here at NYU, and I'm soon to graduate. Very excited about that. But with the topic of this panel, like the path forward, I'm curious kind of what the charge of today's symposium is for people in like my situation. I'm about to enter going into civil rights and criminal defense like litigation after I graduate, and we've kind of expressed some concerns about like courts' competencies in dealing with history or interpreting Reconstruction history. So do y'all think it's still advantageous to be trying to put forth alternative arguments or perspectives of history towards the courts, or should we be communicating a different narrative or strategy? And then the second part of that question is that it seems today we've also talked about two types of like Reconstruction histories. Like one is like likening the harms of slavery that the Reconstruction Amendment sought to redress, and then how the rights were exercised in the Reconstruction era. And so I'm curious if you have thoughts on which versions of those perspectives or types of history is more advantageous for progressive goals today.
I love that our last question is from a student. And I also love that you asked one of my last questions, which was going to be, what advice do you have for young people who are going out into the world with their law degrees to do great things and good things and justice-oriented things? So we have a minute.
I think there is no answer except to keep fighting, you know. Back in the 1890s, I'm sorry about this thing. When I was teaching, I could, people didn't need a microphone, but anyway, yeah, Frederick Douglass in, I think it was 1893, said in a speech something to the effect that, you know, principles that we thought had been firmly established have now been challenged and overthrown. And that is the situation we're living in today also. Frederick Douglass didn't just throw up his hand and say, oh, well, we can't do anything about it. You know, he said, let's go out and continue fighting, of course. But that's the answer. You know, when in that same decade, John Swinton, who edited a labor-oriented newspaper in New York City, went to London and interviewed Karl Marx, and he said to Marx, what do you see for the future? Marx did not say capitalism or socialism or anything. He said, no, struggle. That's what I foresee for the future.
Yeah.
So that's what, whether you like it or not, that's what we're heading for.
Yeah.
I'll say something more concrete, and I'm. It's been a while since I was a newly minted lawyer, but I will say that in terms of where I wanted to go, I was perhaps unduly preoccupied with being in a major city like New York, Chicago, San Francisco, DC, and I understand the appeal of those. I grew up in Port St. Lucie, Florida. Like, I understand the appeal of a big city. But a lot of the work I learned when I was a young lawyer working in New York City, like the things I really, really wanted to work on, reproductive rights, civil rights, it wasn't necessarily happening in the way I was expecting in New York City. Where the work that I wanted to do was in the place where I didn't want to be, right? It was back home, it was in the South, it was in the Southern District of Mississippi. I mean, I think that's something you have to wrestle with. Like, I wanted the comfort of being in a city and all that that meant when the work I thought I should be doing was in a place where I would be profoundly uncomfortable. And that's a hard balance to strike, and not every young lawyer has to make it, so I acknowledge that. But I know you are a Marshall Motley scholar, and you have to go back to the South. So I'll just say the work that you will do when you go back to the South is going to be vitally important. The communities you serve will be vitally important, and I'm glad you are not making the mistake that I did.
Well, I think that newly formed lawyers should take on the abolitionist struggle that is continuing and unfinished. And that means working in the courts, in legislatures, to shrink the unjust systems that we have now and to represent people who are trapped in those systems. You know, most of my work right now has been directed at abolishing the family policing system, otherwise known as the child welfare system. And we're working to do whatever we can to shrink the system as it stands now, passing laws that give parents and family caregivers Miranda rights to know their rights, ending mandated reporting, ending involuntary drug testing, which means drug testing Black people to take their children away from them. And that's, lawyers are essential to that. Family defenders are essential. You know, some people say, well, that's part of the system. You know, you shouldn't be part of the system. I don't know any parent who's had their kids taken from them who hasn't said, I'm so glad I had a lawyer, or I wish I had a lawyer. And so that's essential. But the other piece of it is working to build a society that doesn't separate children from their families as a way of addressing child poverty, for example. That doesn't rely on putting people in cages to address human needs. How do we build that society? And that's something lawyers can be part of as well, but you have to be part of it in connection with a movement. And you find an organization, whether it's in New York City or Philadelphia or Mississippi, they exist. Grassroots organizations exist, and work with them to do that building part of the role. And there's so much to be done, and I think it's an exciting time for lawyers to be part of that struggle.
So I want to wrap us up for today. This has just been a really rich day, and lots, I think, for all of us to think about. Before I say my very final words, I want to say some thank yous because I was raised right. I want to thank Professor Murray for having the great idea of this, definitely. I want to thank Jennifer Weiss-Wolf, who basically said to me, if you want to do it, and then let me do it, which is really wonderful as well. And then nothing like this comes together without a lot of people behind the scenes who are working administratively. If I had just been in charge of this, we would have had it in the park and we would have CVS snacks. But that's not the case because Shirley was here and lots of other folks, Claire, Sherry, Megan, all of these people who sort of made sure that we were able to be here today and have a good time today. So many, many thanks to them. A very, very deep thank you to all of our panelists who came here today and who shared their expertise. And as I said at the beginning of the day, there's going to be some depressing stuff, but also some things that are uplifting. So hopefully we are leaving here with a little sense of uplift. And then the last person who I very, very much want to thank is Peggy Davis. So one of the things that sit down, everybody. One of the things that my father says all the time is that when you care about somebody, you give them their flowers when they're around. And I'm so deeply grateful that we had this opportunity to give Peggy her flowers. So many of us in this room, many of us who spoke today, are either alums of the law school and were taught by her. Many of us were in the lawyering program and taught in the lawyering program and were mentored by her. She's really the reason why I am in the academy 20 plus years later, and just learned so much from her. And honestly, I just have to say that we should all be so lucky as to have a career that is as bountiful and generative as Peggy's has been, because her work will live on for so long because of all of us. And I want to end with another quote from Neglected Stories, which I think is especially apt at this point. So she wrote in that book, "The final word, then, is a plea for what my colleague Sarah Burns calls a willing suspension of belief, for the courage to rethink doctrine and other canonical stories in light of the stories we have been apt to forget." So let's all go out and do that today.